Thank you. Good afternoon, everyone, and welcome to the third and final CLE segment in the Practicing Before Board series being put on by the Administrative Law Section and the Florida Government Bar Association. My name is Charles Greenberg. I'm the chair of the Administrative Law Section CLE Committee, and on behalf of the Administrative Law Section, the CLE Committee, and FGBA, we're glad you can join us. Just so that you are all aware, as the recorded voice has already advised you, this is a recorded presentation. Today's CLE is licensing, declaratory statements, variances, waivers, and rule discussions before boards. Our presenters today are Justin Vogel and Chad Dunn. Mr. Dunn is a partner at Pennington, PA in Tallahassee, Florida. His practice focuses on administrative law matters including licensure defense, licensure applications, certificates of need, and rule challenges. He has previously served as Deputy General Counsel for the Florida Department of Health's Prosecution Services Unit, where he led enforcement actions across more than 40 healthcare professions. Mr. Vogel has worked for the Department of Business and Professional Regulation since 2014. His first duties involve prosecuting administrative actions against licensees before the Construction Industry Licensing Board and the Florida Real Estate Commission. He has served as legal counsel for the Florida Building Commission since 2017 and provides guidance to the commission on a variety of legal issues, including rulemaking, the issuance of declaratory statements, and granting waivers from certain Florida-specific accessibility requirements. I'm going to hand over the CLE to our presenters at this time. Thank you both for agreeing to speak to us today.
Thank you so much, Charles, for the introduction. Good afternoon, everyone. I am Chad Dunn. Thank you all for joining us on your lunch break, and welcome to part 3 of Practicing Before Boards. Part 1 of this series covered discipline before boards, and part 2 covered tips and tricks. Today, Justin and I are here with the board equivalent of the kitchen sink: deck statements, variance and waivers, rule discussion, and licensing. If you go to any larger boards meeting, you may see every one of these on any given agenda item. So our goal today is to share our experiences specific to practicing before regulatory boards. This is not intended to be a comprehensive procedural manual on how to do each one of these things. But before we dive into the individual topics, there's some core features of practicing before boards that we think are generally applicable to all of the items we're going to discuss today. If you joined us for parts 1 and part 2, you may recognize some of these, and that's because the people that practice in this area think it's important. So Justice, can you kick us off and chime in with what you think are some perspectives as board counsel?
Sure. Thanks, Chad. And welcome, everyone. As Charles noted, I've been working for the Building Commission for a number of years now, since 2017. The Building Commission's main mission is to promulgate the Florida Building Code, and so we are frequently involved in extended, very detailed rulemaking processes to accomplish that task and keep the code up to date. The Commission also does frequently receive declaratory statement petitions, and we take up some waiver requests. So our business touches on a lot of the topics we'll be addressing today, and I hope I'll be able to share some useful information with you. And so to start off, as an overarching principle, I think that probably the most important thing that you can do to be successful and is to make sure that you really know that your board and you do that research ahead of time. The more that you know and understand the board, its processes, its members, their interests and their concerns, and their level of knowledge about the laws regulating their area of jurisdiction, the better equipped that you're going to be to successfully advocate before them. And each of these facets is important in its own right. Your best bet for being successful is to take a holistic approach to understanding how to present the issue to your particular board or commission. If you frequently practice before a board, then you'll probably organically tend to develop this type of understanding over time. But if you are deliberate about seeking out the type of information that will be most important to you, then I think that you can accelerate the time frame for achieving that, and also potentially lay a lot of the groundwork in advance of ever actually appearing before the board for the first time. So probably, obviously, the best way to familiarize yourself with a board is to attend one of its meetings in advance, preferably when you know it will be taking up an issue that has some bearing on an issue of concern to you. For instance, if you're thinking about submitting a petition for a declaratory statement, see if you can observe how the board takes up and disposes of someone else's petition. If the board meeting is being held via teleconference or is even just being streamed live, then it could be very convenient and easy for you to do this. But if the board meets in person, or if it isn't taking up an issue of interest to you anytime soon, then one tip is that past board meetings may be recorded, and these recordings may be available. With the Florida Building Commission, we record the audio of all of our commission meetings and all of the meetings of the many advisory bodies to the commission. And we make all of those recordings available on the commission's website. So you could go back, look through past agenda, and essentially get an opportunity to go back in time and see how an item of interest was handled on a particular occasion. I don't know if lots of other boards do this, but if I were going to be appearing before a board for the first time for something important, that's definitely where I would start. See what they have available on their website and maybe reach out to board staff and see what's available from past meetings. If the board that you're appearing before is one that has meetings that are all day long, then you may want to focus on the parts of the meeting that are relevant to you. If the meeting is only a couple of hours, though, then I think that there'd be value in sitting through the entire thing just to see how the flow of a typical meeting goes and what the atmosphere is like. Some specific things to pay attention to are whether there's going to be a staff analysis presented to the board, what the sequencing of things will be, and if there is a staff analysis or if there are other parties, potentially adverse parties, who will also be addressing the board on the issue, who goes first, whether there is an opportunity for rebuttal, etc., and also whether there are any time limits on presentations, because there very well might be, and you may not be given quite as much time as you'd like to present your case. So you're going to want to have as good an understanding of how the board meetings are conducted in advance as possible so that you can prepare yourself and tailor your remarks accordingly. Chad, did you have some general observations you wanted to share?
Yeah, sure. And I agree with everything you said wholeheartedly. Prior to joining Pennington, I prosecuted healthcare professionals on behalf of the Department of Health for almost 10 years. I primarily worked with the Board of Medicine, but through my roles as Chief Legal Counsel and Deputy General Counsel, I appeared before just about all of their boards, from dentistry to acupuncture to psychology and physical therapy. So my lens today comes from experience with those boards. But now at Pennington, I help licensed professionals with their issues before boards. And before we jump into the specifics, I just want to make sure everybody's on the same page about what a board is. And so boards are groups of licensed professionals charged with regulating their profession. They can range from anywhere from as few as 4 appointed members to up to 12. The majority will be practicing members of their profession, but will also include some members who are not members of the profession, called consumer members. In Florida, most of the professional and occupational licensing boards are appointed by the governor. And while they can only be removed for cause, practically these members are going to support the governor's position on policy issues. I did have a few pictures I wanted to share with everybody just to kind of give a frame set of what a board meeting looks like. So if you give me 1 second, I'll share my screen. And hopefully you can see that well. Is that good, Justin?
Yep, I can see it.
So board meetings happen across the state, usually in hotel rooms. If you go to a board meeting, they're probably going to be held in a ballroom of the hotel. There's typically a U shape at the front of the room with board staff, board counsel, and the board members, and 2 tables across from the board that will be one for the department and one for the licensees that are appearing. Some boards like dentistry, chiropractic, and massage often encourage attendance from students at any given meeting. So particularly if you go to the dentistry meeting in Gainesville, you can expect it to be full of students, like this photo that I took here. I think this was a nursing meeting, but all those people in the audience they're just there to observe. They don't have any business on the agenda. So it just adds another layer of complexity to your meeting. And then this was another meeting. I believe this was a committee meeting. You can see it's much smaller. The people there are just there for the business to be heard, but it's the same setup. U-shape at the head of the room, a table for the licensees, a table for the department, and then some audience members just hanging out. While the health boards use the same workflow to process all of the work that comes before them, meaning how they rely on staff, how they publish their materials, the board themselves couldn't be more different. Each board has its own personality, unique preferences, and as Justin said, to the extent you can get to know that ahead of time, it will benefit you and your client. Because for better or worse, if you practice before boards, the board is your judge. Board members may be experts in their field, but they're not lawyers. So you may find yourself trying to persuade non-lawyers on the law. And just like with your reputation before a judge, your reputation and integrity matter to the boards. If you have sloppy materials, unprepared clients, you make unsupported arguments, the boards will come to expect that from you, and you'll lose credibility with them. Likewise, the agency has to appear before those boards all the time. So if you're asking their attorney to take a leap with you and do something out of the norm, give them a good reason to do so, because they've built up goodwill with their boards, and you want to make sure you take care of them as well. So now we've kind of laid the groundwork for everything we're going to be talking about today. I've heard people are really interested in the declaratory statements. This doesn't get brought up in CLEs a lot. So why don't we move into our discussion on that? Justin, do you want to get us started?
Sure. So declaratory statements are agency opinions regarding the applicability of a statutory provision, rule, or order over which the agency has authority as applied to the specific factual circumstances of an affected party. Section 120.565 of the Florida statutes and Rule 28-105 of the Florida Administrative Code govern DEC statements. And there's also a body of case law that has grown around them. They're meant to offer legal clarity for a future course of action, not address conduct which has already occurred. They cannot be used in lieu of rulemaking, where rulemaking would be required to change an existing rule or formally create a new one. They cannot be used to inquire about the conduct of another person or entity, and they can be declined by an agency if the matter is already part of another judicial or administrative process. Chad?
Yeah, I really feel like deck statements are an often misunderstood tool in administrative practice. In theory, it sounds great. It allows a licensee to bring a set of facts before the board and get a binding interpretation of how the board intends to apply a specific statute or rule before they undertake that action. However, in practice, boards, from my perspective, hate them and often look for ways to deny them. And if you're a private legal practitioner, you generally do not want to submit a petition for declaratory statement unless you already know the answer to your question. And the reason for that is once the board issues a written opinion stating that your client's intended course of action is not permitted, that opinion effectively forecloses your client's ability to proceed. So if a client comes to you with the question of legal permissibility, they're considering doing something new in their practice, or they're just not sure if a business that they want to open is viable under the law, I would suggest forming and preparing your own defensible legal opinion on the issue instead of asking the board for a legal opinion. Your opinion may still be that the conduct is not permissible and the law doesn't allow it to occur, or your opinion may be that the conduct is allowed, but there needs to be slightly different circumstances and you can advise your client on how to be compliant. But your opinion is between you and your client, not a final order of the board. So unlike all the other topics we're going to discuss today, declaratory statements are final agency action once they're issued. They're not subject to a disputed fact hearing under 12057. You can't litigate the issue at DOA. Review only occurs by appeal to the DCA. So in a lot of circumstances, it may be better to ask for forgiveness than permission on the back end when you can support your rationale or your client can for doing something. On the board side of the table, it appears to me that their concerns are that deck statements are going to tie their hands in ways they don't want them tied, particularly where the answer could limit future discretion or be perceived as establishing policy or especially forming an unpromulgated rule. In practice, the most common way that I see a deck statement resolved is that the board will just openly discuss the issue at the meeting, give an informal opinion from individual board members, and then decline to issue an actual written statement. So the board will just have a discussion with the petitioner. They'll try to get a flavor of what they're trying to do, understand where they're at, what their goal is, and then individual members will offer their opinion on whether they think the conduct is permitted. So they may be the case where, oh, we think the statute or the rule is very clear in this regard. Of course you can do what you're intending to do. Or, I don't know, in my opinion, this is not going to fit within the law, and this is definitely not something you should undertake. This allows the board members to signal their position without formally committing to it. And while that acts technically as a denial, it can still be useful because you can order a transcript of the meeting because there's always a court reporter at these meetings, and you can use that transcript to provide some measure of protection, even though it's not a binding opinion of the board. One other thing I'd add is if you do go down the declaratory statement route, is appearing at the meeting is essential. I don't believe I've ever seen a petition for declaratory statement succeed on paper alone without the petitioner there to clarify the facts. It's pretty difficult to make a concrete set of facts in a petition, and the boards are going to want to ask some questions to bring that to light so they feel confident if they are going to issue an opinion that they understand actually what you're asking. You see this a lot with pro se individuals. Last thing, if you do decide to go down the declaratory statement path and things go sideways at the meeting, the board's clearly going to shut you down and render an unfavorable opinion, you can always ask to withdraw the petition before they submit it to writing. And Justin, I'd really appreciate if you could add some perspective as board councilors. I'm sure there's a whole nother side to this equation from the other end of the table.
Yeah, sure, Chad. And I thought this might be a good opportunity to offer, some differing viewpoints because, well, I can see why petitioners might interpret agency wariness about deck statements as hating them or wanting to avoid them. From a board council perspective, I frequently see deck statement petitions which are asking the commission to take actions which are clearly outside the scope of what declaratory statements are intended for. We get a lot of petitions submitted by people who are not attorneys, like you mentioned, and who are trying to use the process to attack third parties or in lieu of civil litigation that's clearly going to be required for their issue, or because they've already gone and done something and now are facing scrutiny over their actions from somewhere else. Lots of clear red flags. Even from attorneys, we'll frequently get very broad questions seeking statements of general applicability, completely untethered to any real fact pattern. I think that the relative ease of seeking declaratory statements seems to invite some looser submissions, and a board or commission that's composed of non-lawyers, like you mentioned earlier, could easily find itself stumbling into legal messes by issuing opinions that are outside of its jurisdiction. So as board counsel, you're going to try to protect your client and keep them out of trouble, even if that means being a stickler from the point of view from the people seeking the deck statement. And I think that a useful practice tip here would be to consider reaching out to board staff with a draft of your petition before submitting it, perhaps as part of a general inquiry about submitting a petition before that board if you haven't done so before. They may be willing to offer some informal feedback. As an example, with the building commission, our technical director evaluates petitions from a technical perspective, and I take a look at them from a legal perspective before we send them to be filed. And if there are some obvious issues that could potentially be fixed by the petitioner, we'll frequently give them a courtesy call to discuss our concerns so that they can at least consider those before deciding whether to move ahead as is. We try to be transparent and help people avoid wasting time unnecessarily, especially when they might be able to clean things up. Other boards that may be leery of doing that, it probably depends on their past experiences, but I think it's worth seeing if there's a staff contact that is regularly involved in processing the deck statement petitions who might be willing to talk to you. It'd also be a good idea to look at past examples of deck statement petitions that have been taken up by the board. You might be able to find old deck statements on the board's website. Again, as an example with the building commission, we have a searchable database that lets you search by code edition, subcode, and various other categories. We have them all hosted here, and you can really zoom in on what you might be interested in. If the board website doesn't have a good list, then your next best bet would probably be looking on the Florida Administrative Register's website. If you go there and you go to the advanced search feature, then you can select the department, then the board or commission you're interested in, and select notice of declaratory statement, pick a date range, and get all of the notices published in that time span. I've done that myself when I've needed to just find some example deck statements from other agencies and boards. And so there should be a brief description of the petition and a point of contact for getting a copy of the statements that you're interested in. And while we're on the topic of declaratory statements, I saw this would also be a good time to discuss a couple of board-specific issues that you'll want to keep in mind kind of in general. And these are whether there's going to be an advisory body that'll take up the issue first and make a recommendation to the main board, and also whether there's going to be a staff analysis presented. Starting with advisory bodies, boards may have subcommittees that meet separately and provide guidance to the main body, especially if the main board has jurisdiction over a subject with a lot of different specialized subfields. And for example, in the building commission, we have at least 17 at my last count, different technical advisory committees, program oversight committees, or special work groups, which provide recommendations to the commission about a myriad of issues, but particularly rulemaking and declaratory statements. The technical advisory committees, or TACs as we call them, are each dedicated to subfields involved in building construction or design. So we have one for electrical issues, one for plumbing, one for structural, and so on. And they're typically comprised of a couple of commissioners, building commission members with expertise in the field, along with maybe 6 to 8 non-commission members who are appointed to serve on the various TACs by the commission's chairman. So if you submit a deck statement petition to the Florida Building Commission, your petition is actually going to be heard twice. Once by whatever TACs have expertise in that field, and again by the entire commission. A lot of the substantive discussion about the merits of a petition will go on at the TAC level because that's where the experts are. So it's pretty important to attend those meetings so that you can influence the TAC's recommendation. So definitely be aware of whether your board or commission has any kind of similar sub-bodies, because each of those has their own membership, personality, and thoughts about things, which may not always align with the parent board. And the flip side of attending the advisory body meetings is realizing that they are ultimately only making a recommendation, and the main board might go in a different direction. We frequently get petitioners who will attend the TAC meetings but skip the commission meeting where the final decision is rendered. Sometimes that's because the commission is meeting in person and there'd be travel involved, and the issue may not be very controversial, so they feel confident that the TAC recommendation is going to be adopted. But sometimes people skip the commission meeting even if it's via teleconference and it would be easy to attend. And I think that's rolling the dice unnecessarily. Just realize that you're not necessarily done after receiving a favorable advisory body recommendation. And the other point I wanted to address was staff analyses. You should have an idea whether it's customary for a staff analysis to be presented at each stage of the process. If so, and you're going to have a staff analysis that is acceptable to you, then you may seriously want to consider whether you should be saying much more than the fact that you agree with staff's analysis and are available for any questions. Because if you've already laid all the groundwork in your submissions, and typically you should have, then I wouldn't consider yourself obligated to go into a big presentation, especially in the absence of some kind of indication that it's expected or necessary. Sometimes you can open doors or raise questions that could derail the answer you're looking for. On the other hand, if you have a staff analysis or an advisory body recommendation that is not in line with your desired outcome, then you should be prepared to respectfully explain why you think the board should adopt a different line of reasoning. But that's something that you're going to establish by becoming familiar with how your board takes up those petitions. So I think that probably just about covers declaratory statements. Chad, do you want to talk about variances and waivers for a bit?
Yep. Variance and waivers, I do think, can be a useful tool, and they're used when strict application of a board rule will produce an unreasonable, unfair, or unintended consequence when applied to a specific individual. Unlike a deck statement, in my experience, boards are more receptive to these requests because the relief is limited to an individual licensee with a demonstrated hardship. So a person subject to a rule may seek a variance or a waiver by demonstrating two key things. First, that the purpose of the underlying statute will be or has been achieved by other means. And second, that strict application of the rule would create either a hardship or violate principles of fairness. Importantly, this relief only applies to the board's rules. Boards have no authority to grant variance. Well, Justin's going to tell you the commission's maybe the one exception to that, but typically boards have no authority to grant variances or waivers from statutory requirements. That's beyond their authority. So what you have to show when you submit a petition for variance or waiver is that the underlying statute's still going to be met. So the statute has some requirement, and then the board's rule expands on that, hopefully within their authority for rulemaking. The next thing you have to show was substantial hardship or violation of principles of fairness, and those are defined. A substantial hardship is an economic, technological, legal, or other type of hardship that's specific to the requester. And principles of fairness are violated when the literal application of a rule affects one person in a manner that's significantly different from how it affects other similarly situated people subject to the same rule. They're often said together, variances and waivers, but a variance is actually a modification to all or part of a rule as applied to a particular person, whereas a waiver is just like it sounds. It means that a person is exempted from all or part of a rule. Requests for variance and waivers usually involve atypical circumstances that a rule did not fully contemplate. In the medical healthcare regulation field, these requests can be triggered by outdated rules, emerging technologies, or evolving professional standards. One recent example was the Florida Board of Medicine had an old rule for the prescription of obesity drugs that just became outdated. The rule was originally promulgated in response to the fin public health crisis in the 90s, and it required strict physician involvement when issuing weight loss prescription drugs. Fast forward to 2021, and there were new weight loss drugs on the market. Fin had been banned. And so this led to a number of practitioners. I think there were like a dozen petitions for variance filed with the board. And those variance petitions were all successful because the board realized that their rule needed to be changed. And ultimately, the board did amend the rule in 2022. The board had to amend the rule because variance and waivers cannot be used to fix a systemic problem. Each petition that was filed was limited to the individual petitioner. For example, a physician group may have wanted a variance or waiver, but the board doesn't regulate groups. So the individual physicians within the practice group had to submit petitions and get rulings as to the specific licensees. Another very practical use of the variance process is in initial licensures. So if you have a board rule that imposes a rigid deadline to complete or pass an exam, for example, a petitioner can seek variance to allow additional time based on a documented hardship. Maybe the applicant has had deaths in the family, or they've suffered some type of illness, or a financial hardship that has prevented them from completing the exam within 1 year. You can bring that case to the board and ask for a variance to allow an additional year or however much time, 6 months, depending on when the exams are scheduled, in order to allow the applicant another opportunity to take the test. And the reason this is allowable is because typically the statutory purpose of competency and public protection are still being met. It's often a board's rule that imposes a specific time in which to take the exam that the statute requires. Board's makeup here can have a huge impact on the likelihood of success or variance of a waiver petition. Different board members, different boards all vary in how receptive they are to hardship arguments. So to have an effective petition for variance or waiver, you really need to explain the hardship or why there's going to be an unfair result if the rule is strictly applied to your client. And this is really a case where you can try to tug at the board's heartstrings if they have those and try to make an emotional appeal. Board members, despite being professionals, they're not judges. They're people. Well, judges are people too, but they're not lawyers. So they may listen. They may be receptive. They may have had their own personal struggles in their life, and some boards are really receptive to a sob story. So, Justin, what would you like to add on variances and waivers?
Well, I think this topic is another good example of the overarching principle of knowing your board, because my experience with waivers is probably atypical, like you've alluded to, but it makes for a good case study in the importance of knowing why, or knowing any unusual legal provisions which may apply to the board you're practicing before. So as I've mentioned, a lot of what the Florida Building Commission focuses on is development of the Florida Building Code, which is adopted by rule. And ordinarily, you can request a waiver or variance from a rule. Chapter 120, however, happens to have a specific provision that prohibits the Building Commission from granting any waivers or variances from the building code. If you look at the end of Chapter 120, you can find a big list of agency-specific provisions which override the general rules for things. So it's worth checking to see if there's anything back there which might affect you. These provisions could also be scattered throughout other statutes, though. For example, although the Building Commission can't issue waivers or variances from the code, the Department of Health is authorized by Chapter 514 to grant variances from code provisions for public swimming pools and bathing places, and they don't even promulgate the rule. And DOH even has an advisory review board which is charged with taking up those variance requests, so it fits in very well with our talk today. In a similar vein, while it's true that you can't usually waive statutory provisions, in the Building Commission's case, it has specific statutory authority in Chapter 553 to grant waivers from certain statutorily derived Florida-specific accessibility provisions. And those are the only waivers we handle. The statute has certain guidelines and criteria for their issuance, and there's an advisory council involved, and the commission has some rules which apply to the process. All things you'd want to know if you're seeking one of those waivers. So these commission oddities may be uncommon, I don't really know, but I think they underscore the lesson not to assume anything. The usual rules may not apply.
I think that's a really fair point. Always check to see if there are exceptions related to your particular board. The end of 120 is packed with all types of exceptions. So while as administrative law practitioners, we generally lean on 120 for everything, there are on occasion exceptions. And I think the Building Commission is one that I learned about that I thought was really interesting. So do you want to kick us off with some rulemaking?
Sure. So boards frequently have rulemaking authority, and one of the ways that rulemaking can occur is by someone with a substantial interest formally petitioning a board to adopt, amend, or repeal the rule. This triggers a response from the board either to take the requested action or to publish a statement in the administrative register explaining why it isn't going to. Based on my experience, I feel like a formal petition to initiate rulemaking should be something that you only consider using as a last resort. Unless you're dealing with an extreme situation where rulemaking is pretty obviously required, I don't see the petition as having a particularly high likelihood for success, and you're not going to be doing yourself any favors regarding your or your client's relationship with the board. I think that the better path is generally going to be sustained attempts at persuasion rather than compelling board action. Also, something to consider is that the agency response is required within 30 days, and since boards typically have their schedules prepared well in advance, If you do submit this type of petition between meetings, you could wind up requiring them to have to convene a special meeting to take it up. It's not going to make anyone happy. So if you would like a more receptive audience, it would behoove you to consider coordinating with staff and submitting your petition at a time when it can be included on an upcoming meeting's agenda. Chad, do you want to talk about some other rulemaking scenarios?
Yeah, no, I think your point on the petition is fair. I think that is the least common route of rulemaking. Uh, Boards, at least the health boards, are constantly involved in rulemaking. They can initiate their own rulemaking. So boards are almost always engaged in some form of rulemaking, and public comment is available at those meetings. Board-initiated rulemaking typically begins if the board staff identifies a statutory change which requires the board to engage in rulemaking, or the board itself notices recurring issues in either licensure or disciplinary cases, and it's something that they feel like their rules aren't quite addressing and that they want to affect change with, or there's just changes in the professional practice over time and the rule becomes outdated, and so they open the rule up to make some changes to get it caught up. As an example, just this week, the Board of Medicine published a notice that it will conduct a work group related to the implementation of a new stem cell therapy bill that was passed. And if you didn't know, you can sign up through the FAR to receive meeting notices via email. It's a good way to stay in touch with your boards and find out when they're going to be holding business. For this type of board-initiated rulemaking, the initial discussions are usually really conceptual rather than technical. At a public meeting, the board members will talk at a really high level about what they think the rule should accomplish or what changes there should be to an existing rule. They'll discuss the types of problems that they're seeing, but the actual drafting of rule language is almost always delegated to board counsel or board staff. As a result of that, progress tends to be slow and unfolding over multiple meetings. Like Justin said, you got to know when your boards have meetings. So some of the larger health boards meet every other month. Some of them might meet once or twice a year, and at least in person. They may meet telephonically. So as a result, you get a first meeting to discuss potential rule language. Then board staff or board counsel goes draft some language and they come back. There'll be another discussion about the language. Maybe it didn't hit the right mark. They'll go back, do some more drafting, they'll bring it back again. And so this happens over meeting after meeting. And from a practitioner's perspective, early engagement in this process is going to be necessary to meaningfully shape the outcome. The more discussion there is, the more the boards get entrenched and hardened in their positions, and the more they become supportive of the draft language. So if you can get in on the front end, if there's a particular issue your client is concerned about, you have a meaningful opportunity to affect change in the rulemaking process. And is there anything you wanted to add about that?
Yeah, Chad. I guess one counterpoint that came to mind while you were talking is that while board counsel probably is involved with drafting a lot of the rule language, it might depend on the rule. Like with the building code provisions, there's actually most of the proposed changes to the building code come from interested parties and industry groups, and they're submitted and they go through a very intensive level of review by the tax and then ultimately the commission. And so there's frequently with building code development almost no involvement that I have at all in helping to tweak that language. So it'll probably depend on the board. You may actually have a pretty good opportunity to have an impact on the ultimate rule language if it's a particularly technical topic or just depending on how the board goes about conducting that business. And I was also going to chime in, kind of in a similar vein, that if you're presenting a complex topic as part of a rule development workshop or situation, it could pay to reach out to a staff member in advance to discuss the best way of presenting it to the board, because there may be flexibility in how things can be arranged on the agenda. And it could be that the sequence in which you present certain ideas may be important to having a coherent argument. There may be independent parts or threshold questions that could impact later decisions. We'll see this if we get a long list of interrelated code modifications where if you don't take one, then maybe they all need to be excluded as well. And so if that's the case, if that's the situation that you're looking at, I'm pretty sure that the board staff would appreciate a heads up in advance. And there may be ways to organize the rule workshop to make things more efficient and less confusing for everybody.
That makes sense. Most boards, like I said, that meet regularly usually have a rule agenda item on any given meeting. But if a board that you're working with notices a proposed rule, they're not automatically required to have a hearing on it. And so if you have an interested stakeholder that wants a hearing, you can request a public hearing on a rule. And these hearings are handled very differently by the board. Some treat them as routine and they may just listen to your concerns and then go on about their business, but others will engage substantively. They'll ask for questions, they'll ask questions, they'll give comments on it. Again, board counsel or a designated facilitator typically defines the scope of the discussion and keeps the conversation tethered to the proposed language. Reason being is that sometimes there are aggrieved stakeholders who are upset with the statutory directive of rulemaking, which the board has no authority over. So you can have aggrieved people show up at the meetings and throw a fit about the substance of the rule that the board was directed to draft, but that's not something that the board has control over. From a practical standpoint, I would suggest that you tie your comments directly to the statutory purpose and try to use real-world examples to illustrate why there could be unintended consequences of the proposed rule language. And a client's appearance is not required for rulemaking, but it can be helpful if your client can give practical impacts or industry insights or some type of realities or expertise that the board would appreciate. And like Justin said, there's outside stakeholders at these meetings, at larger board meetings like medicine, construction industry, dentistry. They're always going to be attended by their statewide associations or counsel for their statewide associations like the Florida Medical Association or the Florida Dental Association. And those associations' participation carries great weight. So if they stand up and they give a position on a particular rule, the board's going to listen to them because those associations have tons of members throughout the state. Another tool that you have in rulemaking that's not quite part of the rulemaking process is in initial licensure or disciplinary matters. You can threaten a rule challenge or use it as an advocacy tool, even if it's not formally litigated. And this typically arises if there's an opportunity to point out that a rule that the board is relying on to adversely impact your client may be invalid, improperly adopted, or beyond the board's statutory authority. And raising those concerns usually puts a board or the board counsel on their heels, and they may not want to go to the mat on that rule. And so it could change how they question, or how they seek to enforce that rule against your client. Justin, what's been your experience with rule challenges or rule challenge threats?
Well, I won't go into any extensive detail about my experience, but I will say that if you're thinking that you may have to go the challenge route, then I think it's worthwhile reaching out to board counsel separately and well in advance of any deadlines for you to file a rule challenge, and preferably as early on in the process as possible to discuss your concerns. The style and format of presentation that you have to make during a public hearing are radically different from a frank and formal conversation between attorneys. And though you should count on needing to do both, I would just make sure that both sides have a good understanding of the other's position and concerns, because sometimes things that may seem like problems can be resolved with a little extra communication beyond what you have to offer as a public comment to the board.
I couldn't agree more. From my time at health to now, board counsel is a great resource, and the health boards are represented by the Attorney General's office, and they're always great assets. In my experience, they will listen to you and take your call and at least try to work something out. And Justin, as a board counsel, is telling you, reach out to me. We can have a conversation. So I think that is probably one of the top practice tips we can give you throughout this presentation is any of these issues from deck statements to licensing. If you've got something particularly tricky, call up the board's counsel, see if they have an opinion, because like I said, the board members are not lawyers, and the board's counsel is going to give them legal advice. And so if you can get the board counsel's take on an issue, whether it's for you or against you, that can be really helpful to frame how you proceed at the public meeting. Some other general tips for rule-related interactions are just maintain a constructive and respectful tone. Boards are far more receptive to thoughtful engagement than to arguments that are particularly adversarial or accusatory. Once defensiveness sets in, it's hard to change their mind on something, even if it's an otherwise valid point. Be prepared to offer alternative language or workable options. Again, at least for the health boards, a lot of the drafting is done behind the scenes. So if you've got something that you can propose that would be acceptable to the board, feel free to bring that to the table. Also, keep in mind that there's an institutional context in which rulemaking occurs. There's staff influence, there's board member turnover, there are political considerations sometimes because these members are appointed by the governor. And so the presence at a board meeting, just make sure you keep all of those factors in mind. If you're trying to affect a change that's really difficult, there may be some other factors at play. Finally, be aware that the more time and attention a board devotes to discussing an issue on the record, the more of a record they develop, the less likely the resulting rule is going to be found to be arbitrary or capricious in a subsequent rule challenge. So typically boards don't mind having hearings on rules because it just builds a really good record for what they ultimately adopt. And if that rule is challenged at DOA, there's a robust record as opposed to a rule that's made mostly in the dark. Justin, do you have anything else on variances and waivers before I go into licensing?
No, I think that we're
Or rulemaking, sorry.
Yeah, rulemaking. No, I think that covers everything I was going to talk about.
All right, licensing is one of the core functions of a regulatory board. It's, in my opinion, probably the bulk of their business. Either initial licensure or licensure discipline makes up the majority of any given board meeting. And it's through the licensure process that boards ensure that applicants meet the minimum requirements to enter the profession. So they have to decide on the front end, should we allow you into this profession? And then once they're licensed, the board is charged with whether or not to impose discipline and what discipline is appropriate for any given case. Part one of this series focused on discipline already, so today we're going to try to focus more on initial licensure applications. The first thing that you need to know is the difference between board staff's authority and the board's authority. Board staff are department employees that prepare the agendas, they prepare the materials, they perform initial completeness reviews of licensure applications. And for most applications, the overwhelming majority do not require an appearance before the board. So some boards fully delegate routine, non-discretionary license approval to department staff, while other boards allow staff to submit recommended list of applicants for approval, and they'll approve these ratification lists at the meeting. However, when a license application requires discretion in decision-making, that will result in the file going before the board for consideration. While boards cannot waive statutory license requirements such as mandated examinations or specific education requirements that are found in statute, they do have discretion when the statute uses language like equivalent, comparable, or other similar terms that give wiggle room. And of course, as we've discussed, if a board's rule is what's an impediment to your client's application, there is the opportunity to ask for a waiver or a variance. So almost anything that a licensee can be disciplined for can also be a basis for denial of a license. Most of the time, if the board can deny an application, they can also approve it with conditions. I would say the most common reasons that applicants have to appear before a board at any given meeting is criminal history, prior licensure discipline, impairment issues, or they have some type of unusual credentials. The first one of those, criminal history, there's usually two sets of categories for any given licensee. There are some crimes that by statute just require a denial. In the health realm, for example, Chapter 893 felonies, which are those related to controlled substances, have non-discretionary timeouts that range from 5 to 15 years, depending on the degree of the felony. That's a statutory mandated denial, and there's nothing the board can do for you if your client has one of those type of convictions. However, most criminal convictions, there is a question of discretion. Common examples of convictions that will bring you before a board are ones that involve dishonesty, violence, impairment, things like DUI, battery, fraud, forged checks, things like that. And the boards in those instances have to determine whether or not the applicant's conviction either relates to the practice of their profession, or they may have a character or moral turpitude provision in their statutes that they have to review, or they may have to determine whether it impacts the licensee's ability to practice safely. Maybe they have an impairment concern. Keep in mind that the board will have the police report, the other criminal documents, the criminal pleadings, and so you need to obtain the board's file ahead of time in order to be able to prepare your client thoroughly. And things to consider with criminal convictions are their mitigating factors, how long ago was the conviction or the underlying event that led to the conviction, what did your client learn from the event, how have they changed their behavior, were all of their criminal conditions satisfied, And we'll talk about some more things to do to prepare your client, but that's kind of the general things you look for with the criminal conviction case. Licensure discipline can bring an applicant before the board, and that can be if they've had the same professional license disciplined in Florida or another state. They'll have to appear before the board and explain the circumstances of that discipline. Again, make sure you get a copy of the materials so you know what the board is looking at the time of the meeting. The boards are given materials typically a couple weeks in advance. So they've reviewed a ton of stuff before the day of the meeting. And so they're going to have some opinion already, and you need to know what that opinion is based on. With prior discipline, consider the underlying basis for the discipline. Was the offense that occurred in another state, would that have been a disciplinable offense in Florida? Sometimes other states have laws that can lead to licensure discipline that wouldn't have even been grounds for discipline in Florida. You also need to consider how is your client going to explain this to the board? And importantly, what's the status of the license? Was the discipline license, is it free and clear now? Are they eligible to reapply? Are they still under conditions like probation or monitoring in another state? If they are under conditions still, you can, at the minimum, expect similar conditions from the license issued in Florida, if not a potential denial. The next big category is impairment history. Most board meetings, you'll see someone on the licensure agenda that has some type of impairment concern. And these are applicants that the board has a concern they're unable to practice with reasonable skill and safety due to use of alcohol, drugs, other material, or as a result of a mental or physical condition. Now, this could be self-disclosed on the application. Some applications ask applicants to identify whether or not they have an impairment issue or have been treated for substance abuse in the past. Or it may be apparent from a criminal conviction or a prior discipline that an applicant has a substance use history. Some examples are if you have one or more DUIs in the last 5 years, if you have prior licensure discipline for substance abuse, if there's criminal convictions for public intoxication, disorderly conduct, battery offenses involving bar fights, things that might raise a red flag for staff to put it before the board, and then the board has to decide, does this constitute an impairment? If the board is concerned with an impairment in an application, they're really going to be looking for one, public safety, and then two, rehabilitation. So they're going to want to know, has the applicant been evaluated by anyone? What were the results of the evaluation? Did they undergo treatment? How long ago were the incidents? If the applicant claims they're sober now, how long have they been sober? And if it's a mental or physical condition as opposed to a substance use issue, they'll want to know, does this condition require ongoing treatment or monitoring? So maybe you're able to practice under certain conditions, but the board's going to want you monitored to ensure you're safe to practice and you comply with those conditions. So in those types of cases, the most likely outcome is the board will issue a license with the condition that if the applicant hasn't already, that they get assessed by an approved provider and then comply with any treatment recommendations following that assessment. The last big category of licensure cases that come before the board are just unusual credentials. So you can have foreign trained applicants, and the question is typically, do their foreign education qualifications meet the Florida standards? And there are third parties that do this type of analysis. The Educational Commission on Foreign Medical Graduates will certify whether or not foreign transcripts meet the Florida standards. The other big one is gaps in training. So if you have an individual that was credentialed 20 or 30 years ago, maybe in another state, and they don't qualify for a reciprocal license in Florida, there may be Florida-specific education requirements that the applicant doesn't meet. Maybe they qualified under a prior version of the statute and it's changed now. I think Tim Atkinson gave a good example in part 2 where he had a client who was a builder or a contractor for 30 years, let their license lapse, and when they went to reapply, the board was like, hey, you have to take this exam, it's required now. And they weren't able to waive that because it was a statutory requirement. So Justin, can you tell us a little bit about appearing before boards for licensure matters?
Sure, and I see that we're running up on our time limit, so I'll try to go through this quick, sort of bullet point style. Just first, remember that you're going to have limited time to make your presentation before the board, probably under 10 minutes. Make sure you know how much to expect to be able to have. Make sure that you prepare your materials in advance along with any necessary exhibits for your case. Ensure that you know what the submission deadlines are, submit them on time, and don't show up with a stack of papers the day of. That is usually not going to work out well. reach out to board staff and obtain a copy of any materials the board's going to be relying on in advance, and make sure your client reviews those and be prepared to address any concerns about their credibility. And I guess in general, licensing matters before boards are driven primarily by the imperative to protect the public. And so just keep that in mind as far as the arguments you're going to make. Most boards are generally going to express a willingness to help qualified individuals obtain licensure. DBPR's motto is license efficiently, regulate fairly. If you can provide compelling evidence of rehabilitation or compliance with applicable laws, then you'll increase your client's chances of success.
I think you're exactly right on that. You want to do as much work on the front end, submit a letter of explanation with exhibits that give a firm feeling in the board's mind that they should grant this license. If your client is required to appear, though, especially for criminal convictions, impairment, or prior discipline, it's almost guaranteed they're going to get questioned by the board. So you need to prepare them for that. You got to imagine this is a group of their peers that's going to grill them about a negative life event. So you want to have them, one, prepared for that. Two, there's a court reporter there that's going to swear them in. And one, there also might be an audience. So I think the best course of action is treat it almost like a deposition. Answer the questions that are being asked of you. Only answer that question. Don't try to fill dead space with just rambling and going on. What the boards are really looking for is candor, non-defensiveness, and clear communication. Half of the time, the client's presentation can decide whether or not it's a yes or no. And so what the board's looking for is self-reflection and insight. What could I have done better? What could I do differently? Inability to answer questions confidently and victim or patient blaming are guaranteed to derail your case. So I think we've made it almost to the end of our time. There's one other thing specific to health that I wanted to mention is that license application denials can be their own basis for denying a future application, whether in the state of Florida or other jurisdictions. So whenever I represent a licensee, whether or not it's a health board, I always try to find out if a denial will be held against them in the future. And oftentimes the boards, if they're going to deny the license, will give you the opportunity to withdraw instead of having that official denial on the record. And so it could be to your benefit to take that. So I think we've covered everything we set out to cover. It was a lot of ground to run through, and I hope you've all taken something away from this that you didn't know before.
Well, thank you both for presenting today's CLE on licensing, deck statements, variances, waivers, and rule discussions. As you previously stated, the kitchen sink of practicing before boards. We appreciate both of you sharing your insights on these many different matters. The prior sections of practicing before boards shall be available soon on the section's website and will be separately provided to FGBA as well. The administrative law section hopes that you'll consider joining or renewing your membership. It keeps you up to date, informed of our upcoming events, and goes towards happy hours and CLE events. Since 1964, FGBA has existed to provide a voice for government lawyers and to promote and foster professionalism and collegiality in government practice. FGBA is known for its monthly continuing legal education, providing networking opportunities, and engaging in charitable and pro bono work with partner organizations. If anyone wishes to present a CLE, please contact me. My email address is charles.s.e.greenberg@gmail.com. Of course, if you have any feedback, please reach out to me as well. And the moment you have all been waiting for, the CLE number is 9585. Again, 9585. I've also placed that CLE number in the meeting chat, so it is available to everyone. I'll leave that up for a couple of minutes so that I can make sure that everyone records the CLE, but after 3 minutes, we're just going to end the recording. Thank you all for attending. And again, thank you, Mr. Vogel, Mr. Dunn, for presenting today.
My pleasure.
Thank you for asking us, Charles.
Bye.
Of course.